So the computer finds that more than 15%. Yes.
Coming back to page 279, that is procedural aspects. F and G, G, it is held in favor of the Public Service Commission that you can increase the number of posts. F, if your lordship will please to see, F, my lords will get at page 15 of the written submissions.
Yes.
What is F, my lord, according to the judgment is disclosing of unqualified candidates' hall ticket numbers in the mains final marks list. But this is regarding those 925, my lord, who did not qualify in English. The allegation is their marks should not have been corrected at all. And their mark sheets, my lord, all their subjects were, my lord, evaluated for the reason that tomorrow in the event, my lord, though they fail in English also, the other subjects are, my lord, evaluated for the reason that tomorrow if they apply for recounting and if they pass, my lord, they can't do the recounting at that stage, my lord, revaluation at that stage. Therefore, all the answer scripts were evaluated. That is found fault. Page 15 of the written submissions, evaluation of answer scripts of candidates who did not qualify in English. Contention of the appellant, according to para 12(1)(d) of the recruitment notification, the paper on English is a qualifying exam.
Yes.
According to paragraph 12(1)(d) of the recruitment notification, the paper on English, general English, is a qualifying examination and different qualifying marks in English are prescribed for different categories of candidates. 40% for OCs.
Yes.
Sports quota of EWS 35% and BCs 30%, SCs and STs physical. The evaluation of all the 7 papers of all the candidates is done simultaneously, and in view of the confidentiality, it is not possible to know the category of the candidate while evaluating the English paper. There is also an option for recounting in all the papers provided as per paragraph 15. Thus, it is imperative to evaluate all the 7 papers of all the candidates. The final marks list published on 30/3/2025 contains list of all the candidates who appeared for all the 7 papers and does not confer any right on any candidate, much less on those candidates who did not qualify in the English paper. The same is misrepresented by the writ petitioners to be the general ranking list, which is not the case. The writ petitioners have not pleaded how they are prejudiced on mere publication of marks to the candidates who did not qualify in English, who in any case are ineligible to secure employment. My lord, the consideration of the court in respect of this is, your lordship will find it at paragraphs 331 at page 295 of the judgment. Same judgment, 295. Volume 2, my lord, the judgment part which your lordships are now seeing.
Yes.
Starts at page 294.
Yes.
Disclosing of unqualified candidates' hall ticket numbers in mains final marks list. The commission filed an additional counter affidavit dated 25/6 in the said counter. Para number 76 reads as follows. Further, the petitioners have also alleged that the commission, by the press note dated 15/4, declared that 10 persons from Urdu medium appeared for all 7 papers in the mains examination. While web note dated 13/3/25 reflects a figure 9 Urdu medium candidates. As clarified above, the web note dated 13/3/2025 contained the details of the candidates who have qualified in English paper, which is mandatory for evaluating the answer scripts, suggesting that only 9 Urdu candidates have qualified in the English paper. The petitioners are deliberately misinterpreting the figures published by the commission at various intervals and raising speculative allegations. Paragraph 323, the 332, 295. The purport of Rule 212D of the notification, the paper of general English is a qualifying one. The minimum qualifying marks in these paper are for the candidates belonging to OC so and so. The marks obtained in these paper are not counted for ranking. If the commission, para 333, if the commission had followed the above method in evaluating answer scripts candidates who scored less than 30 out of 150 marks in general English qualified, would have become ineligible for the evaluation of the remaining papers. But surprisingly, in the marks list in the mains examination shows as follows. In respect of various other candidates, the above table indicates that candidates who were disqualified in the qualifying examination English general, but their other papers were also evaluated and total marks were published, which contradicts their own rules. This itself, what rule is contradicted is not mentioned. This itself demonstrates how the transparency maintained by the commission in evaluation of the answer scripts. The commission, being a constitutional body in the process of Group 1 mains, deviated from the mandatory rules. There are no rules there, which is unacceptable, and it shows that there is no transparency, fairness and integrity in the conducting of the examination. It appears that commission violated the principles of natural justice, which is unconstitutional. The acts of the commission reflect that it causes injustice to the unemployed youth who have a strong hope of serving government employment and has been waiting for the last 1 decade. So nothing is mentioned over here. We have given the reason, my lord. The reason is all the answer scripts were, my lord, evaluated simultaneously in respect of all the candidates. You don't know who is passed, who is not passed. All the answer scripts, that is 7 answer sheets of all the candidates, 21,000, were evaluated. And my lord, English also, there are different qualifying marks for each of the person. You don't know who is there. Therefore, you evaluated all. Also, my lord, in the event one candidate has failed in English and he applies for re-evaluation, in the event he passes, you can't start re-evaluation of that answer scripts of that person, my lord, separate. So all the answer scripts of all the persons, my lord, who appeared for the mains examination were evaluated. That is found fault.
So, if understood correctly, the observation of the learned writ court is that if somebody was not qualified in the qualifying English paper, why did you evaluate the other papers? But your contention is from the commission that we do not know as to whether he is first of all qualified or not qualified. All papers are evaluated simultaneously, and in case in recounting he qualifies
in English,
then there will be another round of evaluation of the remaining papers.
Therefore, we took it upon ourselves, my lord, to evaluate all the answer scripts of all the candidates who appeared for the mains exam.
Very good.
Irrespective of the English marks.
So this final mark sheet, whichever, after that 1 week period reflected all those.
All. That is how it is evaluated.
Huh. So this procedural aspect is over.
And my lord, the marks are secured by all the 21,000 candidates, my lord, were put on the website of the Public Service Commission. My lord, that is not ranking.
No, that's
all the marks were declared.
Here there is no interview in this.
No interviews are there. You have done away with it, my lord. For all, my lord, group 1, group 2 and 8. And my lord, the mark list of all the candidates of 21,085, my lord, we filed that at page 435, volume 3, page 435, my lord.
This mark sheet is of all those who qualified in all papers.
No, my lord. The total marks of all the candidates in all their 7 papers. In all the 7 papers. Some of them, my lord, failed in English. My lord, they will not be considered. 924 people failed in English. My lord, they will not be allowed, my lord, even irrespective of what marks they get in other subjects, my lord, they will not be there in the, my lord, merit ranking.
So this list is of all those who sat for the written exam.
Yes, all 7 papers.
Excluding that sports quota.
7. All 7. Some of them did not write 7 papers. If you don't write 7 papers, then marks were not. They disqualified.
Very good.
My lords, may kindly take the second part, my lord, method of evaluation.
Yes.
Method of evaluation.
Yes.
My lord, method of evaluation, my lord, is procedural aspect and method of evaluation. Under method of evaluation, my lord, A is selection of evaluators at page 279, my lord.
Yes.
Internal page 179 of the judgment of the learned single judge. My lord, 2 is method of evaluation. A is the selection of evaluators. My lord, in the written submissions at page 16, page 16, my lord, the selection of evaluators and multiple evaluation. Sure. My lord, insofar as page 16 is concerned, my lord, selection of evaluators and multiple evaluation, both have been, my lord, put in paragraph 10 at page 16. The contention of the appellant is that, my lord, the appellant has been historically engaging well-known and renowned subject experts for the purpose of evaluation of the answer scripts, who are currently in service and also who have been in service. This procedure has been followed across all the public service commissions in the country, including the Union Public Service Commission. The writ petitioners have picked up a stray observation in a press note. My lord, it's not part of the, my lord, notification. Stray observation in a press note dated 13/3/2025, and have contended that only serving experts in the respective fields have to be engaged for evaluation. Such an approach would deprive the benefit of expertise of retired professors who are well versed with the subject. Further, the Honorable Court took upon itself the task of examining the marks obtained by one candidate with hall ticket number 240 so and so, and came to the conclusion that the said candidate got shockingly less marks after putting in 10 to 12 hours of hard work. Further, the red petitioners falsely contended that one M.A. Malik, who is alleged to be associated with R.C. Reddy IAS Study Circle, was an evaluator and is guiding students from the said institute. In fact, the said evaluator is an associate professor of the Government Degree College, Chevella, since 2010 and is no way connected with the said institute since his appointment to government service. At any rate, the selection of the evaluators is entirely within the domain of the appellant, and the writ petitioners have not pleaded any prejudice with respect to the same. Further, the appellant had evaluated.
Yes.
Further, the appellant at page 18, further the appellant has evaluated the answer scripts by two evaluators, and further by another evaluator as contained in details in paragraphs 49 to 64 of the common additional counter affidavit at pages so and so, 49 to 64, we read to your lordships, and the same be read as parcel of these written submissions. In all laid down by the Honorable Apex Court, I will bring all the judgments at once for your lordship.
Yes.
My lord, the whole of the case, my lord, seems to revolve, my lord, regarding Sanjay Singh judgment.
Yes.
My lord, your lordship permits, my lord, we bring Sanjay Singh judgment for your lordship's consideration.
You can just, if may, after that also, and if you can just formulate the ratio which.
Yes. No, my lord, I can, judgment I also was telling, my lord, we'll bring it to your lordship's notice at one go in the last. My lord, I will only bring that the consideration by the court, by the writ court, my lord, your lordship will get it at 19. 19, my lord, in respect of this issue.
Yes.
19D. Dr. M.A. Malik is one way or other guiding the students in R.C. Reddy IAS Study Circle. The evaluators were overburdened. There is no proper evaluation, transparency and fairness. The entire evaluation process undermined the sanctity of the Group 1 examination at para so and so. Your lordship will please to see page 339, page 298, my lord. 298, my lord, of this judgment, only to show to your lordship, my lord, how the writ court, my lord, considered this issue. Page 298, my lord.
Yes.
Para 339. After completions of the main examination, the Commission evaluated all answer scripts from 1/11/2024 to 31/1/2025. That is 90 days. The Commission issued press note dated 13/3/2025 with regard to evaluation and to transparency. As per the said note, all evaluators are the regular faculty from the universities, government colleges, institutions, and two retired faculty members have also been used as evaluators. To substantiate allegation, the Commission stated that the list evaluators are confidential to ensure fairness and anonymity, and that the petitioners who are already in the government service have abused their office to secure the list of evaluators. The letters addressed by the Commission to the Commissioners of Police have been filed along with their writ petitions. Commission reserves the right to initiate appropriate legal action against the petitioners for illegally procuring documents and using them in the present proceedings as per Rule 3 of the Public Service Commission rules of procedure. It is right. If it is right, the Commission has to take action against their own employees who supplied the details of the evaluators. Instead, without doing so, threatening the petitioners is incorrect. Regarding regular faculty, the Commission stated that it does not exclude retired faculty members from this definition. It is a standard practice from the public service across the public service commissions from retired faculty members to evaluate the answer scripts. In these, the Commission observed two things. One is regular faculty do not exclude retired faculty, and second, one is standard practice across the Public Service Commission to use retired faculty members as evaluators. Both are different. As per the Commission's notification for the evaluation purpose, only regular employees will be considered, whereas the petitioners allege that retired employees were also considered for evaluation. Moreover, the press note dated 13/3/2025 was issued after the evaluation process completed. One of the evaluator, my lord, page 300, running page 300, internal page 200, between my lord, one of the evaluators, Dr. M.A. Malik, who worked as a private tutor, was used as an evaluator. The petitioners alleged that the person favored in his own students. The commission asked with substantiating the allegation about this evaluator, stated the said evaluator has been working as an associate professor at Government Degree College since 2010 and has not taught a single class at R.C. Reddy IAS Study Circle since then. The commission to that extent produced by the letter dated 24/2025. The commission said that the said evaluator approached the advocate to issue legal notice to all the petitioners in WP number. However, the fact remains that the particular evaluator wrote the book on Indian economy in Group 1 mains, for Group 1 mains, which is published in the year 2024 itself. In the said book, while introducing about the author, Dr. M.A. Malik stated that for the past 22 years he is contributing insightful articles on the economy. Insightful articles on the economy for competitive examination in the Andhra Jyoti, Telugu daily newspaper, and for Vivek, a monthly magazine by R.C. Reddy publication. It seems that the author guides the students of the R.C. Reddy IAS Study Circle in Hyderabad in one way or the other. Knowing fully well about the author particulars, the commission, without accepting the same, pretended to file cases against the writ petitions. With regard to regular faculty, the commission's reply is incorrect, saying that the regular faculty does not include retired faculty members. As per the service law, regular faculty means a person who is currently in service on a substantive post, appointed according to rules, either on probation or confirmed. He is still drawing salary and discharging. Since to overcome these lapses, finally the commission changed the meaning of regular faculty. To be informed, my lord, for the reason that across the country, my lord, all public service commission, including the UPSC, my lord, uses the services of retired professors for the purpose of correction of answer sheets. Otherwise, you will not get enough people, my lord, as subject experts. My lord, the procedure of evaluation also, if you are not sure. My lord, next is Telugu medium candidates were neglected, if you are not sure, please. C.
The questions of these exams were for 7 papers.
All 7.
And 7 everybody had to face.
Had to write.
And the question papers were set by someone else.
Yes.
Nothing to do with the evaluators.
Nowhere. And that's not the allegation also. None of those allegations are there also.
No, this particular last paragraph 340, last part.
Yes.
The Telugu daily newspaper, Vivek, etc.
My lord, his book, my lord, that's his book, my lord, Dr. M.A. Malik's book. He writes books, my lord, he writes various books. But that doesn't mean, my lord, that he has done something. But we have brought to your lordship's notice that no evaluator, no matter who, will never know whose paper he is correcting.
I'm sorry to interrupt, my lords. Can I just say one thing? There are totally 351 evaluators. 351 of which Malik is just one. Just want to let you know.
Very well.
My lord,
the breakup of the number of evaluators, my lords, is at page 448. 448, subject wise, the entire table has been provided by the commission.
Yes. Yes.
my lord, a paper, my lord, from one of his books, my lord, he has written certain books, my lord. on Indian economy and all that. One of the book, my lord, the last page, my lord, on the paperback, my lord, at the back of the paper, you write, my lord, as to what is that you have done, my lord, the author does in these earlier publications and all. That is filed, my lord, before the learned single judge at page 457, my lord, before your lordships also, volume 3, in which he writes, my lord, that he has guided some of the, my lord, IAS, at the IAS study circle. Page 457, my lord, volume 3. Here. Volume 3 at page 457.
About 457.
457. My lord, 457. My lord, this is a book which he wrote on Indian economy. My lord, most of the professors across the country write, my lord, books or guides, my lord, for the purpose of examinations. My lord, about the author, your lordship, this is by Vagdevi Publishers below, my lord, about the author. He is a distinguished associate professor of economics, Government Degree College, Kukatpalli. My lord, he was then there. With an impressive 22 years of teaching experience, a prolific author and researcher, he has published 20 books and 26 research papers. Dr. M.A. Malik has also dedicated around a decade to coaching aspirants for competitive examinations at R.C. Reddy IAS Study Circle, Hyderabad. There are other things also. This is found fault with over 10 years of experience. K.C. Reddy Malik R.C. Reddy has been guiding countless students towards success. Prolific writer, regularly contributing insightful articles on the economy for competitive exams in Andhra Jyoti Telugu daily newspaper for the past 22 years and for Vivek, a monthly magazine R.C. Reddy's publication. This is what the publisher prints about the author.
This book was of 24.
20.
Yes.
My lord, next is method of evaluation in respect of Telugu medium candidates. Method of evaluation C, my lord, Telugu medium candidates were neglected. My lord, in the written submissions, it is addressed at page 20, my lords, para 12.
Yes.
Page 20, para 12, my lord, of the written submission. Contentions of the appellant. Alleged neglect of Telugu medium candidates. It is a specific contention of the appellant that the degree college faculty teaches both English and Telugu medium graduation students. Page 20, para 12. A comparison of statistics with the neighboring state of Andhra Pradesh reveals that the percentage of successful candidates from both the states is more or less equal. The entire exercise of evaluation was carried out with the best possible practices available and no injustice is caused to any candidate irrespective of the medium in which the papers were answered. It is relevant to submit that out of the total 563 vacancies, about 56 are occupied with Telugu medium candidates, 10%. Consideration by the court. The appellant is comparing the candidates between Telangana, which has a 2-tier recruitment, and Andhra Pradesh, which has a 3-tier recruitment system. There is no fairness and transparency in evaluating the answers list, and that it is clear injustice has been done to the Telugu medium candidates. My lord, in both the states, my lord, the successful candidates, my lord, are 10%. Only to compare, my lord, between two similarly placed states. My lords, the learned single judge, if your lordship will please to take page paras 357 at piece 311. Page 311, my lord.
Yes.
Telugu medium candidates were neglected. Page 311, my lord, para 357. One of the allegations is that who wrote Group 1 examination in Telugu medium, their answer scripts are neglected and not evaluated in a proper method. To substantiate the Commission's arguments as well as in the common affidavit, they submitted as follows. Degree college faculty teach both the English and Telugu medium graduation students and are competent enough to evaluate the Group 1 mains exams. For all languages, adequate numbers of evaluators who have taught and who are teaching in the respective mediums have been identified by the Commission. The Commission thoroughly identifies and accommodates the subject experts from across the country. Again, this answer is showing the ambiguity of the stand of the Commission. There is no specification of how many evaluators are allotted for English script evaluation, Telugu script evaluation and Urdu script evaluation. In any answer scripts, English version and Telugu version may not be the same. There must be a different verbatim in English and Telugu. Another shocking aspect is that on 16/4/2025, the Commission issued instructions in the open court. In the instructions, one of the documents with heading Important Instructions of the Candidate is that point number 32 reads as follows. The evaluation purpose, though English version would be taken as a reference under normal circumstances, a balanced view would be taken after comparing English, Telugu and Urdu version of the subject area. As per their own instructions, if the evaluators are experts in three English, Telugu, Urdu, they would have had a reference in each language. Then a question of English version taken as a reference under normal circumstances would not arise. The second answer referred to by the Commission is that the evaluation of the Telugu medium candidates' answer scripts fully justified. To support their argument, they compared the neighbouring state Public Service Commission Telugu medium qualified candidates with that of TGPSC Telugu medium qualifying candidates. However, the reality is that Public Service Commission APPSC follows, Andhra Public Service Commission follows 3-tier system, that is prelims, mains and interview. That means Telugu medium candidates are filtered in 3 stages, whereas Public Service Commission Group 1 Telangana candidates filtered only in 2-tier, that is prelims and mains. This is the reality how the Commission compared the qualifying Telugu students of Andhra Pradesh and the Telangana state. It is very miserable, and also they said in their additional counter as follows. But the court went on to write page 36, para 360. To support their arguments as document number 4 captioned as Andhra Pradesh Public Service Commission Vijayawada. Statement of candidates for medium wise for Group 1 services stated that as per the tabular form, 3,900 candidates appeared. Out of that, 11 from Telugu, 59 from English, and total 76 likewise. 18, 2,482 for Telugu medium, 6,053 in English medium, total 9,679. Out of the said number, 14 from Telugu, 151 from English, in total 165 were selected. In 2022, 1834 from Telugu, 4381 from English, total 640. The selected candidates out of this, 9 from Telugu, 102 from English, total so and so exams. But it's more or less 8% to 9.98%. The court finds fault saying that you can't compare yourself with Andhra Pradesh for the reason that there is an interview there also, you don't have an interview. The issue is regarding evaluation of answer scripts of the Telugu medium candidates. It was done, my lord, in the most fairest of the manner, and my lord, the neighbouring state also corrected the answer scripts. You go to the interview after correcting of the answer script, my lord, after you clear the answer, written examination only, you go to the interview. My lord, here also, there also, my lord, the number of candidates who got selected at the written examination are more or less same. We just made a comparison. Then they say, there it is a 3-tier system, why are you comparing yourself with them?
Telugu medium means those who have answered all 7 papers.
In Telugu, except English.
Except English.
All other 6 papers.
What is
10% of them have selected.
So what is the complaint about that?
Complaint is, my lord, the answer scripts, the evaluators were not trained in Telugu. The comparison between Telugu and English is not correct.
How do the petitioners allege that? What is the basis?
My lord, to a pointed question from this honorable court, my lord, we are not able to find a proper allegation which is made by them. We hope, my lord, they substantiate it.
some of the writ petitioners were also those who answered in Telugu.
Telugu, yes, yes, some of them.
Very good. Yes.
My lord, D is highest qualified candidates in specific centers. My lord, D, my lord, 379. Page 279, my lord, sorry, page 279. D is highest qualified candidates in specific centers. That 19 and 20, my lord, I bring to your lordship.
Yes. Where are you reading? Written submission. Yes.
Earlier, by many candidates getting access to toilets and the assessment teachers and the hospitals, we are temporarily required toilets. And the center does not have access to toilets for time. The commission has allocated even to the standard the access and the school fee level of procedure rules. The allegations that highest number of women candidates got selected from centers 18 and 19 is also misplaced as a comparison with other centers without this indication. In fact, there are other centers where the percentage of candidates selected is more than centers those 18 and 19, so that's what is just qualified candidates in the specific centers. Consideration by the board will also kindly go to pages 282 for us. Page 282 of that. Page 511.
Yes.
qualified candidates were received. Regarding the highest rank, the commission stated that paper 6 maximum mark is 100 and no candidate has achieved the highest mark in paper 6. Because the candidates were not applied for BCom, the commission has not changed any mark. Only for the candidates who had applied for BCom has been undertaken as per the marks and procedure. Entirely incorrect statement of answer. Change without BCom. The expectation is that the central court 18 and 19, the highest female candidates were selected. Is that the central score 18 and 19, the highest female candidates were selected. To substantiate this, the Commission's Council produced document number 1 in the Tax and Food Services 2024 main examination center-wide overall and female percentage of people in 563. According to their own documents, female candidates were allotted to a total of 58 centers of operation. In centers 18 and 19, 71 female candidates were picked up. It means an average of 35.5 crores per center were selected, whereas remaining 26 centers, 139 female candidates were selected. Whereas in center 18 and 19, whereas there were more than 2,000 candidates. More than 2,000 candidates were selected, were allotted to 18 and 19.
Yes.
It means an average of 5.35 girls per center were selected. The figures are shown as disparity between the average of the two centers and the average of the remaining. Hence, there is a significant amount of variance which is unacceptable, and these figures establish the allegations of the petitioner. Regarding the allegation, and none of the petitioners relate to 18 and 19. No candidate from 18 and 19 are the petitioners, or there were any allegations of anything, of any malpractice or whatever you lost. 18 and 19, 2000, counter the version, counter. And 18 and 19 had only the lady candidates, and all the candidates, they were about 2,000. And their percentage comes to about 5.5 from that center success. And none of the petitioners are there from that center, or there is no other candidate who has written examination in center 18 and 19 have alleged anything wrong happened there. In all other centers except for 2 or 3 centers, had both male and female candidates. And para 366 is regarding Para 366 also, regarding the allegations of the unofficial respondents, it is that without disclosing petitioners' hall ticket numbers and marks, the petitioners do not have locus standard to question the examination. It is incorrect to say because the petitioners filed their hall tickets and memorandum of marks as enclosures in the writ petition. The other allegation of the unofficial respondents is that the writ petitions are not maintainable unless the successful candidates are made party respondents. Also incorrect to say that the fact remains no petitioner is questioning the selection of the successful candidates. Writ petitioners are questioning the acts of the commission such as procedural irregularities and evaluation. Moreover, the selection process is underway. May not kindly take the last of this method of evaluation. E. Commission awarding the same marks to certain candidates. Regarding E, Commission awarded same marks to certain candidates. Will get that. my lord, page 21, my lord, para 13 of the written submissions. My lord.
Page 21.
Page 21, para 13 of the written submission. Now, contention of the appellant. The total number of candidates who appeared for all the 7 papers in the main exams is 2110. The highest mark secured by a qualified candidate is 550 and the least qualifying marks for SC/ST and physically disabled is 270. Therefore, the marks obtained by all the candidates will have to be necessarily between 270 and 550. It is natural that there will be more than one candidate having a total which is similar to the other. It is relevant to submit that in the UPSC examination, out of 1009 candidates who appeared in the mains 2024 exam, 969 candidates have scored total marks which is similar to to some other candidate, which is about 96%. It is but natural that in a competitive examination like Group 1, there will be several candidates with equal marks. Further, though the candidates with successive hall tickets have scored equal total marks, they have scored differently in individual papers. The Honorable Writ Court has erroneously held that 719 candidates secured equal marks, while the record shows that it is different. My lord, may kindly take, my lord, page 1450 at volume 7, only to show to your lordship that this may not be correct because individual subjects they got different marks. My lords, may kindly take page 1450, my lord, volume 7.
Yes.
Page 1450, my lords, may kindly see the main hall ticket number, top 3, my lord, 3rd row. This is the hall ticket number of the candidate, and the total marks secured by this person is 253. 1450, my lord. The top, my lord, is the hall ticket number, and my lord, total marks secured is 253. My lords, may kindly go to the next candidate, my lord, to overleaf, my lord, 2471. Well, it is a next successive hall ticket number.
Yes, we have seen that.
General essay 42 for the 7th one and 43.51. All the marks are though the 14 crore ratio of candidate was successive numbers. 719 are like that, and that is also relevant to the 83188. That all 719 similar. How the citizen knows about 790 cannot be also taken. Page 926 of the
Yes.
We have mentioned that only people are there with similar marks. Page 926.
Yes.
Just now see the number 1, 470 and 471.
Yes.
Marks were secured by 28 candidates.
Yes.
All of them, if I calculate, it comes to 79. And that's how the other executed. There is voting. That 790 people have got same marks on this side. And case 318 priorities.
In case of similar marks, then in final merit list is calculated, what are the principles? In case of similar marks by more than one candidate, the principles upon which the merit list is prepared, what are those in this?
Normally they go back to the marks secured by the
Yes.
Manoj,
Yes.
it's at page 373. Page 373 is the methodology to be followed in case there's a tie in marks, separately for preliminary and then separately for mains. Bottom of page 373.
It is
Para 12.3.
volume. I think it's volume 3 perhaps. Volume 3.
I'm not sure the volume.
Volume 3.
Page 373, para 12.3.
Very well. Yes. Yes.
They mentioned whenever there is a guy, how to look at it. Just reject your marks. Okay, 367, only one paragraph regarding this same marks candidate. That page 380. Page 380. I think this is a level candidate to go to the main exam.
We saw that actually. Yes.
They exclude re-evaluation. What is supposed to be looked at in any case, there should be a specific provision for re-evaluation. Even re-evaluation has to be done. But here, there is a specific exclusion. There shall be no re-evaluation. 247 overly, if you want to keep 247 3D, and 247D, and reevaluation of answers shall not be entertained and ready. So, a counting of marks will be considered in 15 days of the paper. Page 98. Page 95 judgment starts from Kumar Kumar.
There are 7 and 8. There are 29 to 31. There are 30.
32. There are 20. It's 117.
Same judgments, same principle, same judgments have been quoted also. Yes. Moderation. Moderation. Starts from page 149. 147. There are 45 perhaps. Yes.
Having made this exercise of household consultation is good. Also provide that what examination is conducted and the maximum marks for each subject in the examination. So the judicial service is another further of the examinations to be done. The judicial service will not expand the management of the examination and evaluation of answers and award of the final marks and evaluation of the therefore, from the commission to regulate the manner in which we conduct the examination and value the answers to be subject, however, to the provision of judicial service. The commission has made use to respect the procedure and method of the examination. They will naturally apply to any examination conducted by any organization of any subject, including the where the institution continues to make specific provisions regarding any aspects of examination provision to them, and the provision of possible procedure is to that extent in an inconsistency with provision service in that respect. Further, the rules have made provision with regard to a particular matter. The TSC procedure will be to the education service schools. Number 92 by 23.
Yes.
Because that's when the issues are raised by the relevant one of the context was the following question aside for all consideration. If the restrictions are not maintained, whether speeding of marks is conflict or prohibited by the relevant rules. Well, that's what that means. And third is whether the speeding system adopted by the country of event and whether the decision of teaching of the speeding system requires an arbitration. So that is at 23, 166, when a large number of candidates appear for an examination, it is necessary to have uniformity and consistency in evaluation of the answer script. Where the number of candidates in the examination are limited at only one examiner, you don't think the neighbors that evaluates the answer script. It is assumed that there will be uniformity in evaluation. Where a large number of candidates take the examination, it will not be possible to take all the answers to evaluated in the same examination. Therefore, it becomes necessary to distribute the answers among several examinations for evaluation to the papers or other senior persons acting as the exam. This is what is exactly done and narrated before your office. When more than one examiner evaluates the answers to create for the subject, the subjectivity of the respective examiner will feed into the marks awarded by the answers which awarded to him for evaluation. Each examiner will apply both the answers to assess the answers. Inevitably, therefore, even when each examiner receives equal class of answers, there is difference in average marks. The rate of marks awarded thereby affecting the rate of individual candidates. These are partly the off-road effects. Some examiners are liberal in evaluation and tend to award more marks. Some examiners are strict and tend to give less marks. Some may be moderate and balanced in awarding marks. Even among those who are liberal or those who are strict, there will be various degree of liberality. These means that you can be marks very good answer. Very good answers goes to a very strict examiner and mediocre examiner answers goes to a liberal examiner. Mediocre answers may be awarded for marks. Then the excellent answers, in other words, there is a huge valuation and a strict exam and a hard valuation by ethical exam. This is called as examiner weighting or outdoor effect. Therefore, there is need to beyond the procedure to ensure the uniformity. Because the examiner, so many efforts of examiners, of examiner weighting is minimized. The procedure adopted to reduce examiner subjectivity or variability is known as moderation, last method of moderation. However, so far as in these examinations, the participants need to the chief examiner, examines, only examiners, evaluators, they
Yes.
What is the method adopted by the service commission? In order to reduce the examiner variability, he has narrated it at page 932 how the succeeded, hopes to begin the lawsuit at this stage, at this judgment stage, to reduce this examiner variability at paragraph 48 to page 932, we have narrated as to how the evaluators were assessed, were trained, and then reduced further by taking average marks. And difference of 15 marks technically was third point. But there cannot be a better extension. already go also to see page 67. The papers were and the headed that each side senior academic scholars seriously served that where the cases of the large number of candidates of the one examiner each of them is allotted about 3 hours to achieve union of community evaluation where more than one examiner each for the head examiner with all the examiners after the exam. We narrated all that in our comments. They discussed thoroughly the question paper, the possible answers, the weightage to be given, various aspects of the answer. They also carry out a sample evaluation with the type of the answer. The sample examiner evaluation of skills for each of these. Each of them is reviewed by the head examiner and weightage and assigning marks are further discussed. After such discussion, a consensus is arrived at in regard to the norms of evaluation to be adopted. That basic examples are required to complete evaluation of the answers. But this by itself does not think about uniformity and just the example. Inside of the norms, many examples and PDFs is exempted or agreed. Their caution is overtaken by their complexity, liberality or realistic. Therefore, certain further practice will be necessary. After the evaluation is completed by the examiner, the examiner conducts a random sample. Survey of the corrected answers to verify whether the norms reward and duty of the examiner have actually been followed by the examiner. The process of random sampling usually consists including of mock your answers from the batch unless it is valued by each examiner. The mock your answers to succeed examiner are revalued by the detector. The carrying of such process and the different considered as per for 8% necessary circumstances average must be yes over the water. Around the country go to that, maybe go to that. The initial service exam, the candidate required to take the examination all qualified others. In the case of whether it is selected, all have to take this exam. And the candidate did not have any option in respect of the subject. Such a situation, moderation appears to be ideal to do. Because there are examinations which have competitive situations where candidates have the option of selecting one or more among the variety of heterogeneous subjects and the number of students taking different options also vary and becomes necessary to prepare a common merit list in respect of such candidates. Let us assume that some candidates like mathematics as an optional subject and some take English as the option well prepared and marks out of 100. In mathematics, do not mean the same thing as 70 out of 100. English 70 out of 100 we should not be executing so far as our case is concerned because all 7 have to write in the report.
Moderation is applicable when everybody has to write the same papers.
Yes, also not all 7 papers to be written by all. And extensive tagging of the case with another statement. in ways which was very difficult kind of challenge in the fields. The principal basis on which interviewers of the type was not to use that analyze the results of the exam. The participant moderated the marks awarded by the exam. We had scrutinized the answer of the candidate for taking down the marks. This process was required to be undergone in view of the fact that examination and the examination so far as the option of papers are concerned, very different from the candidate most of the earlier order of the stated 2011 March proceeding and research and numbered as well decide to reach about examination score Sundays. Allowed the candidate to have 18.
Yes.
There is no issue that the use of this the opposite has made out the mark awarded to the candidate to follow the stage method. He spoke after voting that use of service to govern the selection did not complete the stage, gave down marks to be taken into consideration. Of the adoption of staging method to an examination, where the papers were compulsory and common to all the candidates. Doing so, it was observed as follows: moderation. Let us kindly go to para 18. Para 18, suggesting the court was considering the validity of the declaration of the results of the examination conducted by the public service administration by adoption of the staging method, which, according to the court, was not to have been done in as much as the staging system is more appropriate to an examination. Use the candidates are required to write the papers in whereas in the examination all the papers were common and compulsory. Come to the opposite conclusion, this court had necessary to analyze the details parameters inherent in scaling down and then to reach its conclusion. With regard to the impact of the adoption of the method in the examination, in question we were recording the consequences that have resulted in application of the scaling method. The details of this regard have already been noticed. The entirety of the discussion and conclusion on this was with regard to the question of the suitability of the scaling down to an examination where the question papers were necessary and common to all candidates. The decisions and construction of the paper as pointed out and described above, where in the above context, it suggesting lay down any binding and inflexible requirement of law with regard to adoption of the staging method of an examination, where the candidates are considered in as in the present examination. Having regard to the context of the conclusions and reach the and opinions were expressed by the court, it is difficult to understand as to how this court is suggesting would be understood to have laid down any binding principle of law or direction or use guidelines with regard to holding of examination, evaluation of papers, declaration of papers by the commission. What was held in our view was that staging the method which was generally suitable to be adopted for evaluation of subjects common to all candidates, and that the application of the said method to the examination had resulted in access to the suggestion did not decide that to such an examination that is where the papers are common and the system of moderation must be applied, and to an examination where the papers are we are unable to find any declaration of law or systems or principles suggesting papers as has been canvassed before us on behalf of the applicant. Therefore, as we understood, we confined the facts of the case, depend upon consideration of the errors of these rules, describing the particular status. We cannot understand the law to be imposing the requirement of adoption of moderation to a particular kind of examination and statement of the both are expressed opinions inside of which requires an in-depth consideration of the issues that are more suitable for the experts in the field. Holding a public examination involves wide and task, which implies an instant solution by adoption of any similar process or by a straight jacket model. Not only examiner variations and variations number of months in different subjects are issues to be answered. There are several other questions that also require to be dealt with. Variation in the strictness of the questions set in a multidisciplinary examination format is one such fine issue that was coincidentally noted in Sunday Singh. A conscious choice of a discipline for a subject by a candidate at the time of entry to the university thereby restricting his choice of papers in the public examination. The standards of inter-subject evaluation and issuance of appropriate directions to evaluators in subjects for all relevant areas of concentration. All such questions and maybe several others are identified herein are required to be considered. These questions, by their very nature, should be left to the expert bodies in the field, including the public service commissions. The fact that such bodies, including the commissions, have held or have actually behaved in a responsible manner in the past cannot be a reason for a pre-exercise more judicial power which, at its very nature, will have to be understood to be normally limited to of arbitrary or modified of exercise. None of that is there for these. To reward in the instant case, they have noticed that the suspect proceedings when 40 service solution for violation of order provide complicated also noting the 40 service solution made all attempts to gather relevant information and other state public services and those that we followed in other states. The information received was to be discussed in the light of the purpose and therefore a conscious decision was taken by the regulator dated 15 months ago, the details of which have been already extracted in the
anything which is over and above what has been held in these cases which you just referred, then only the necessity of multiplying.
Three answers. They were not rules provided for three examiners. Similarly, without rules being provided, we had three examiners, three evaluations. Conclusion part of question. So far as this examination is concerned and the manner in which it was conducted, I don't think, my lord, there can be any other public service commission which has, my lord, done it to such precision, absolute meticulousness. Page 321, if you lordship will please. The reliance placed on Sanjay Singh, my lord, was 321A, my lord, 372, my lord, para 372 at page 320. In view of the foregoing discussions and also taking into consideration the facts, these writ petitions are disposed of with the following directions. Mark list dated 10/3/2025 as well as general ranking list dated 33 are hereby set aside. Respondent authorities are directed to re-evaluate all the answer scripts in Group 1 mains examination by applying the moderation method in terms of Sanjay Singh and another manually and announce the results. Based upon such results, the respondent authorities are directed to take steps for filling up of 563 courts. This court is otherwise this court is inclined to cancel the Group 1 mains examination. The respondents are directed to reconduct Group 1 mains. The entire judgment, my lord, that judgment, my lord, that the evaluators' names, my lord, should be kept as a closely guarded secret my lord, not to be made public, my lord, is this judgment. That judgment, my lord, your lordships have brought, my lord. Taking a cue from your lords. Yes.
Adit Bandopadhyay.
Yes. 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 2011 8 ACC 497. Para 52 and 53. Para 52 and 53, my lord. 1, 2, 3 are the facts. Para 52 and 53. That's all. My lord, then one other aspect is, my lord, insofar as page 929, my lord, volume 4. Volume 5, my lord, in the counter, my lord, we have specifically stated in this lead case, my lord, it was brought to the notice of the learned single judge, my lord, a forced marksman. And my lord, your lordships have seen that, my lord, Pujita Reddy. And my lord, the writ petitioners, my lord, produced that memorandum of marks without the knowledge of, my lord, the candidate, Pujita Reddy. She files an affidavit that I did not produce this memorandum of marks. This is not my memorandum of marks. There is no difference in my memorandum of marks, either before or after re-evaluation. She files an affidavit to that.
That was the item in your list of dates. Yes, sir.
And the remarks, my lord, which are made against an expert body like the Public Service Commission, my lord, may not be warranted. Every care was taken to see, my lord, that the candidates, my lord, are, my lord, provided with everything, and my lord, the examination is conducted in the most transparent and in the most efficient manner.
In the entire submission that you made, there was no issue relating to mass cheating.
Nowhere, nowhere,
Question
nowhere, my lord. No systemic failure, my lord. That's the judgment, my lord, which your lordship says.
First two judgments that you have cited.
Yes. There is no systemic failure at any point of time. No allegation, my lord, of mass copying or anything.
No question paper leak.
No. 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 A systemic failure is on the judgment. Question mark. That's the word you system failure.
Yes.
No allegation of any systemic failure at any place, my lord. None of that, my lord. Your lordship may kindly
Mr. Gopal Narayan would address or Leland Senior?
Yes, I could address if you lordship. I think my friend is present in court. I always believe it's more fair for somebody who's present in court before I trouble your lordship. I can start. I have no problem. But
I can continue, sir. There is no issue if my friend is.
Very well.
Yes, no issue. But if your lordships take the written submissions given on behalf of some of the successful candidates filed on 10/10/2025, my lord. And if I may say, my lord, slightly different than what has been, my lord, written submissions adopted. My lord, the Public Service Commission has gone by the issues, my lord, procedural issues, and then, my lord, the method of evaluation. My lord, we choose to put the returns in the written submissions, my lord, method of evaluation first, because the direction is to re-evaluate, my lord, only cancelling the evaluation. And then we have also answered other issues of procedural lapses which have been formed by the learned single judge.
Lordship may kindly explain.
Yes. If your lordships, but I do not know whether your lordships got it or not. My written submissions and we have unofficial response successful candidates filed on 10/10/25.
Yes, we have it.
Filed by Sriram Polari. Yes. Now your lordships must see, my lord, because I would like to read, my lord, para 372, my lord, from the impugned judgment from the same volume, my lord, which Land Advocate General, volume number 2, 372 para, the conclusion, of course, which has been also brought to your lordship's notice, by the Land Advocate General. At 320 minute conclusion. But in the written submissions, in the order of preference, we have answered this because this is the direction which was given by the learned single judge after the entire conclusion.
Yes.
And then we have given, even with regard to the procedural lapses, where there are some observations made saying that there are procedural lapses. Each one of them also we have answered. Now your lordships must see, in view of the foregoing discussions and also taking into consideration the facts and circumstances mentioned above, these writ petitions are disposed of with the following directions. The final marks list dated 10th March 2025 as well as general ranking list dated 30th March 2025 hereby set aside. Respond authorities are directed to re-evaluate all the answer scripts of the group number 1, group 1 mains examination by applying the moderation method in terms of Sanjay Singh so and so, manually, and announce the result. Based upon such results, the respond authorities are directed to take steps for filling up said 563 posts. But this conclusion, and according to me, with great respect, my lord, nullifies the other findings with regard to the procedural aspects. Because the reasoning which has been given is only, ultimately the conclusion is, that only re-evaluation, which has been directed. Now that the cross appeal has been filed, of course, that will be argued, separately by the council, whoever is appearing for the successful candidates. As of now, in these appeals, the subject matter is of this direction, saying that they should apply moderation as it was done in the case of Sanjay Singh. If you don't do it, then the next one. Otherwise, the court is inclined to cancel the Group 1 main examination. Not because of the procedural lapses, but because if you don't follow this direction, you have no other option other than the conducting examination. This is how, my lord, we started, my lord, in our written submission saying that it is self-contradictory. Having said that there are lapses, court itself has considered that the lapses which have been pointed out and observations or findings by whatever name we call, are not enough to cancel the entire examination. Learned single judge himself was not, prepared to set aside the whole of the examination and direct, because as it said, systematic, failure is not there, systematic. That's what the learned advocate general last submission made, as has fallen from the bench. Absolutely, there is nothing, which has been said, except pointing out some 45 centers have been increased to 46. Second hall ticket number has been given for the main. And these are the procedural things. Learned single judge himself was not satisfied, saying that merely because these things which have been alleged by the petitioners, it is not enough to cancel the examination and direct the Public Service Commission to conduct the exam. Then, this principle with regard to so far as the moderation is concerned, as is suggested by Sanjay Singh, is concerned. Your Lordships must see, courts have only said, Honorable Supreme Court has only said, there should be a method of moderation. According to me, in this case, moderation has been provided inbuilt, in the procedure which has been adopted by the Commission, as has already been submitted by the Learned Advocate General. Why I am saying is, it provides for first valuer and without knowing what were the marks which were given by the first valuer, because that will be torn off. Second valuer will value the paper. But if there is a difference between the two, which goes up to more than 15%, then it will be sent to the third valuer. This itself is nothing but a moderation. This subjectivity has to be avoided and minimized. The purpose of moderation, I point out those paragraphs where purpose of moderation is to avoid the subjectivity of the evaluator. Each of the evaluator have got his own method. So one may be strict, one may be very liberal. To avoid this, the moderation method has to be adopted. The Commission provided a method saying if there is a difference of 15% or more, those papers will be sent to third evaluator. In fact, as I had an occasion to hear the Petitioners Council, one of the submissions made by the petitioners before the learned single judges, there is no evaluation at all. There is no evaluation at all. In fact, during the admission also, my friend appearing on the other side was arguing. But according to them, because the first sheet which has been shown to your Lordship, first is the details of the candidate, and second one is the marks bubbling and all that given by the first evaluator and second evaluator. But what my friend is saying is evaluators are not writing on the answer sheets. They don't write on the answer sheet, but the purpose of moderation will be lost. If they write marks on the answer sheet, they have to write only the place which has been given to them, the first evaluator and second evaluator. And it has been also commented by the learned single judge, I take your Lordship through, saying the third evaluator, similar type of bubbling is not provided. But page 3, third evaluator column is there, because very few number of sheets will go to the third evaluator, because that situation will arise only when there is a variation of 15% of the marks between the first evaluator and the second evaluator. So that's how minimum number of sheets, answer sheets may go. So that's how it has not been thought that it should be again bubbling procedure should be provided. So that's how that by itself it doesn't matter and because very few, and that is also one of the observation made. Now the contention is because answer sheets there is no marking has been given at the margin. Normally this bubbling system before introducing moderation when 3 valuers would be there if there is a difference between the two. But that purpose itself will be lost if answer sheets provide marking there. That's how the contention is, that no evaluation has taken place.
That, I mean, if we have understood correctly, the contention was that against each of the answers in the several pages of the answer sheet,
Yes.
the marking ought to have been done.
Marking ought to have been.
That is missing.
That is what is missing. That's how no evaluation is done, is one of the submissions made.
But in that case, the second examiner
will be knowing the marks which have been given by the first evaluator. That is exactly the point, which I am trying to say. But there will be no meaning, to remove the subjectivity or minimize the subjectivity. I can't say that entire thing can be removed. What could be done, by whichever method, we adopt? We can minimize the subjectivity. For minimizing the subjectivity, second evaluator to whom the paper is sent should not know how much scoring has been given by the first evaluator. Otherwise, there is no purpose. There is no purpose. That's how, the argument saying evaluation itself has not been done, I am only pointing out this.
There might be another confusion as to which one of the marks against each of the answers have to be.
They have to write saying that number 1 and number 2. But with great respect, this cannot be done, because these things will happen, with great respect. Unsuccessful candidates would like to raise. But putting a question similar to this, 45 centers and it has been increased to 46. How does that affect and how does that prejudice the candidates? And with regard to each one of them, I'll point out to your lordships, hall ticket numbers, Land Advocate General has already covered, saying that hall ticket numbers, 2 hall ticket numbers have been given. Preliminary, because they wanted to maintain the sequence, because 3 lakhs have attended and only 30,000 have qualified, and they wanted to give. But one of the observations of the single judges, how is that it is going to help the candidates? But this has never been done to help the candidate. This has been done as an administrative measure. It will be proper. Never it has been said by the Public Service Commission saying that this has been done and this method of giving the second hall ticket number has been given because to help the candidate. You will also to see the observation. But though I am not on that, now I am on the conclusion. But para 307, your lordships must see, these observations, themselves show, how the learned single judge went wrong in its approach. And when the approach itself is wrong, conclusion is obviously wrong. Your lordships must see, yes, at 308, referring to at 281 page, and just giving an example, how the learned single judge in a consideration itself went wrong. The commission did not provide any clarification in a proper manner as to what benefits the candidates will receive by issuing 2 hall ticket numbers. But it is nobody's case, it is not the case of the Public Service Commission. They said it is an administrative measure. So when this is the approach, if you ask a wrong question, the answer would also be obviously wrong. But it seems the learned single judge, and then 310 your lordships may see, in these circumstances, conclusion with regard to this particular procedural lapse, in these circumstances, this court is of the opinion that the entire exercise beginning with the issuance of 2 hall tickets was not as per the notification or rules. The commission's action creates doubts about the conduct of examination. But the suspicions, doubts cannot be the ground for it as it has fallen from the bench. But whether any systematic complete failure, systems failure is there or not, is the criteria, or leakage of paper, or mass copying, nothing of that sort. This is only with regard to saying, issuing, and then this your lordships will find, nowhere in the rule it says second hall ticket number cannot be given at the main examination. What is being said is, the procedure do not indicate you have not notified second hall ticket number. That has been answered saying, in August itself, while the examinations were conducted in October, 2 months prior, it has been indicated to the candidates giving the pro forma, how it will be the present hall ticket number in the main examination and indicating the hall ticket number in the prelims, and also saying that this is the pattern in which they have not objected to it, they have participated. And important aspect which has been, all these findings have been given, saying that it creates the doubt, there seems to be something wrong, but no conclusion, if I may say so, saying that how did that prejudice the petitioners in the examination. How did this prejudice, putting a question to myself, two numbers have been given. What is the effect of it? How it will be not to be a transparent methodology? But they could have gone without, assuming, they could have gone without issuing a fresh hall ticket number. Then what? Putting a question to myself. There is nothing. But second hall ticket number has been given according to them for administrative convenience, which they have elaborated in the counter, saying out of 3 lakhs only 30,000 were selected. We thought of giving this number so that there will be continuity in printing the answers. Because your lordships will see these sheets contain details of the candidates in the first perforated lines out of first page. There are 3 perforated pieces which will be removed to see that, and then if your lordships look at that particular one, be one of the contention, of course that has not been taken by the learned single judge only said, so far as evaluators are concerned, third evaluator has not been provided any place for public. So far as the third evaluator is concerned, only few papers will go. Even if he writes it on the paper, it doesn't matter. Because as I said, number 1 and number 2 should not know. Number 2 should not know what are the marks, and both of them bubbled and separate sheets are there. Number 3 evaluator, absolutely does not matter. Then how it should be calculated, where there is a variation is a method that is not under challenge. According to me, with great respect, the learned single judge failed to come to the right conclusion, saying that what has been done by the commission is nothing but moderation. Nothing but moderation. It has been written because of the fact, learned single judge quoted a paragraph. In one of the writ petitions, one of the paragraph, the contention is scaling down or oblique moderation has not been adopted. In reply to that, commission has said, we did not do it because this examination, compulsory examinations, it is not different subjects and all that. Leaving alone several paragraphs where in detail they mention about the moderation. The question is not about what has been written in the counter. The question is when material has been placed, both need to understand and know whether the principles of moderation to avoid the subjectivity have been followed or not. Your lordships will find those paragraphs, D46, the observation, and then that is the reason why court is of the opinion, learned single judge is of the opinion, that moderation has not been applied. Your lordships will see at 305, I am only taking the relevant paragraphs because in detail the Land Advocate General has already argued the matter.
Yes.
But while explaining the evaluation method, the learned senior counsel appearing for the commission said that on 30th July 2025 there are 3 methods of evaluation in our country: scaling, normalization and moderation. The commission has stated scaling and normalization is not applicable in this examination because scaling will be where different subjects are there, different options are there. The commission fully followed the moderation method in evaluating the answer scripts on 25/6/2025. The commission filed an additional common counter affidavit. In the said additional common counter affidavit, commission explained which type of evaluation followed in para 70. The petitioners in so and so further alleged that no moderation oblique scaling of marks was carried out in the present examination. Submitted moderation scaling is a method that enables the rationalization of grand totals in favor of the few disciplines and subjects, and it is dependent on the pattern and the scheme of that examination. It is adopted in examinations at the discretion of recruiting bodies which involve multiple optional subjects. But this is answering to the scaling method. Though the word moderation is also written by way, this itself is considered saying that you have said something in the counter and what is being argued is something different. However, no such moderation is required in the group 1 examination because all papers are mandatory. Again here all 7 papers are mandatory. What was being talked about is the scaling. This mistake cannot by itself, then no other paragraph has been referred to. In fact, the paragraphs in 49 and to 54 the counter filed by the same additional counter have been totally volume 5 at page 932. Yes.
You have quoted it in your written submission.
Yes, we have quoted, same paragraphs have been quoted in the written submissions. I read from the counter. The petitioners have levelled speculative allegations that evaluation process was hasty and deficient, and evaluators were overburdened. Petitioners have also alleged same evaluators had evaluated both Telugu, English, also. All answer scripts and main examinations are evaluated by 2 different evaluators. However, in case there is a difference of more than 15% of the marks awarded between the 2 evaluations, a 3rd evaluation is carried out. This is nothing but moderation to avoid the subjectivity to the extent possible. The process of evaluation of each evaluator is closely monitored by the chief examiner to ensure that the scheme of evaluation is strictly implemented in terms of uniformity and fairness. For this purpose, chief examiner independently evaluates 3 of the answer scripts already evaluated by each evaluator from each answer booklet, bundle and random basis, and gives guidance to the concerned evaluator in terms of the implementation. This is exactly in terms of the procedure which suggested to be adopted in Sanjay Singh's case, which this has been narrated in detail. All this up to 54 this has been said, and your lordships will see para 54 it has been said. Furthermore, the majority of the evaluators were retained across all phases of the evaluation process in order to ensure continuity, standardization and fairness. It is also pertinent to its theme of the evaluation was followed strictly and uniformly throughout the phase of evaluation without deviation. Accordingly, due diligence was exercised at every stage to uphold the integrity, objectivity and transparency in the evaluation. Putting a question to myself, but the learned single judge has failed to look into this except looking at para 70 where there is either it could be a typographical mistake or it is oblique scaling or oblique. In fact, we read carefully the sentences also, it is said where the subjects are not varied, all compulsory subjects are there. Scaling will not apply, not the moderation. Moderation will be where the papers are the same to avoid the subject. This is how my submission is. Only picking up one paragraph in the counter and leaving the detailed explanation which has been given in the counter saying this is the process. As your lordships know, neither the Sanjay Singh case or subsequent cases have said it is always for the institutions which are conducting the examinations which method of moderation will be applied. But courts will not go into which method should be adopted and which is good and which is bad. It is the institution which will know because they are in the field, they are the persons with experience to conduct the examination and selections. That is the reason why it is always been left. I will point out those judgments also. Your lordships, but immediately I will point out one of the judgments may pass on the compilation, though we have referred to in our written submissions the propositions, the compilation of the cases we have not been handed over along with the written submissions. Now, your lordships' permission. Immediately, if your lordships go to the second judgment, page 37. Yes. It begins at 37. Paras 30 and 31. To save your lordship's time, my lord, I need not read the whole thing. Yes. Is there? Yes. My lord, your lordships will see, my lord, the queries, my lord, have been. But first I will point out, my lord, what are the facts of this case. And
You
then, my lord,
referring to that short,
right, para 30 and 31, my lord, are relevant paragraphs. But before that, my lord, let me point out to your lordships. Para 10, my lord, on the contentions, the following questions arise for consideration. For our consideration, 792 page, under the report, running page 48. Whether the instructions and solutions to questions, if any, given by ICAI to the examiners and the moderators are intellectual property of the ICAI, disclosure of which would harm the competitive position, so whether the providing access to the information are relevant would be, my lord, fourth query, my lord. Whether the High Court was justified in directing the appellant to punish the first respondent. 5 items of information sought in query 13 relating to regulation 39(2) of the Chartered Accountant Regulation 1988. There are 30 your lordships received. These are the base. Yes. Query 13, my lord, which are the query 13, what are the 5 things which have been asked, have been stated in para 28, my lord. Para 28 of the report, page 54.
yes,
Query 13, the first respondent required the appellant to disclose the following information. What is relevant would be, my lord, Roman 2 again. The criteria used for exercising such discretion for revising the marks. With regard to that, my lord, in that context, my lord, this has been answered in para 30. Yes. After extracting Sanjay Singh's, my lord, para 23.
this is the same ratio as in Sunil Kumar versus BPSC also, which was relied by learned AG.
His principle is this, my lord. Institution has to decide. My lord, not the. My lord, once there is a method, my lord, which has been evolved and implemented by the, my lord, commission, it doesn't really call for any interference, my lord. Under 226 is my submission. The same principle, my lord. Ultimately, my lord, it is for the institutions. And it is merely because of that paragraph 70 which has been quoted in the additional counter. But it varies at the oral argument to the counsel appearing for the commission and the additional counter. My lord, leaving alone, my lord, all other paragraphs where in detail it has been explained the method, my lord, how moderation has been taken place. Avoiding the subjectivity, my lord, cannot be, but the proper approach, my lord, of the learned singlages is my submission.
How much more time would you take if you could say?
But I may take half an hour, 40 minutes, my lord, to half an hour.
Because we request not to repeat the.
No, my lord, I am not.
And submissions are very succinct and very.
Yes, submissions are there, my lord. I may take half an hour time, my lord. I will see that, but your lordship's time is not taken, but much of your lordship's time is not taken. Because the approach, my lord, I put it in one sentence, my lord. The question which has been asked by the judge to be decided itself is faulty, my lord. That's where, my lord, your lordships have seen, my lord. How is that it is going to be beneficial to the candidate is the question which has been asked and said it is not beneficial. Whose case it is that it has been done for the benefit to be conferred, my lord, on the candidates. It is for the administrative convenience, my lord. 2 all tickets have been given. So that's how, my lord, with great respect.
If we continue for next 15 minutes, will it be possible to conclude?
Well, I I'll try to. And if your lordships would like to, I'll try to.
So that we can move on to.
True.
I may also take 1 to 10 minutes after tomorrow. Because
You see.
allegations made against me as a Hudu candidate, how did you get so many candidates? They got my ticket number, they got my mark list, I don't know how they got it. And they're making allegation that she got so many marks. 10 minutes only, almost all judgments have been covered too.
Only thing has fallen from the bench. Sunil Kumar is also in our compilation. Subtle distinction between that and this is in Sunil Kumar it has been said. In Sanjay Kumar it is not as a precedent it can be taken. It is only on the facts of that case. No law has been declared. But my case is different, saying in fact the commission has adopted the moderation. But that's where moderation is not compulsory is what Samar Sunil Kumar says. Here my submission to Lordship is citing this case ICAI that moderation is a subject which has to be decided by the institution which is conducting the exam. That is the subtle distinction. I'll point out to Lordship tomorrow whatever time.
So tomorrow we continue.
Fine.
And Mr. Gopal Sankarnarayan, you.
Yes, Lord. Yes, Lord. I have 3 one-page notes just to summarize everything. I don't want to take too much time. I will repeat nothing that has come before.
Have you passed it on, or tomorrow will you?
No. I will hand it over tomorrow if I may, because I'm changing it in accordance with what has been argued so far to distill down. I don't want to repeat anything. Just to summarize it, just 1 page each on 3 points. That's all. And then I'll address your Lordship. I won't take much time unless the Learned Advocate General has dwelt considerably on this.
So tomorrow for the appellants.
5 to 10 minutes I will take so far as my thing is concerned, not beyond that. Promising because promises which have been made is very difficult to convey. I have to, but I have to do it in 10 minutes. I assure your Lordship,
While making the promise itself, my friend is
to that. Because allegations were made against me and my appointment was shut down.
Promise to whom? That side.
My lords, item 54 becomes infructuous, my lord.
54.
Because President is appointed to the Telangana State Consumer Commission and the Honorable Judge has taken charge today.
Very well.
Item 55, Lordships may argue tomorrow, Lordships. After mentioning this matter, Milord, one child died in the Nizamabad district, Lordship.
Day after tomorrow.
60, my lord.
Huh?
54 is this.
60. 60 you want.
54 last year.
60 day after tomorrow.
With my lord's kind permission, item number 51, it may be taken up any day convenient to my lords in next week, because the GP is also reading the matter and would not take more than 5 minutes of my lords. It's a very short issue involved.
51 somebody asked for time, or 52, 53?
51 is not mentioned, my lords.
Okay, then next week.
56. My lords, one last indulgence, interim order may be extended in 51, it is expiring today.
My lords, 56.
Connected to 50. This group, take down. Learned Advocate General has made his submission. Learned Senior Counsel Mr. Pratap Reddy has made part submission for further submissions on his, for further submissions on his part, and learned counsels for the appellant pose the matter tomorrow. And the reply of the writ petitioners pose the matter tomorrow.
Lordships permitted item number 58 on my request it is listed today, but it is not reached. They are
Day after two.
for